interesting topic of conversation to discuss, which is the nature of the criminal justice system at the federal level. There's a new book out entitled Conviction Machine, Standing Up to Federal Prosecutorial Abuse. Two co-authors for this, Sidney Powell and Harvey A. Silverglate, both writing the book Conviction Machine. Sidney Powell is a former federal prosecutor and co-author of the new book Conviction Machine. Once again, the book that I have right here in front of me. She's represented individuals, corporations, and governments in federal appeals for more than 20 years. She's a highly sought speaker and frequent media guest who's appeared on major radio and television programs nationwide and has written extensively for some of our nation's leading publications regarding government and prosecutorial misconduct, and previously authored License to Lie. Powell is a past president of the American Academy of Appellate Lawyers and the Bar Association of the Fifth Federal Circuit and a member of the American Law Institute. Based out of Dallas, she's also an attorney for Michael Flynn, which we will talk about as well in our conversation. Sidney Powell joins us now, again, author of the new book, Conviction Machine. Sidney, welcome to the show. It's so great to have you.
Thank you. It's a pleasure to be with you.
So let me ask you just a broad first question, and then we'll drill in on the book and some of the related topics. Why did you decide to write Conviction Machine? What is so important about it, and what is the book about at a top-line level?
Well, Harvey wrote 3 felonies a day based on the premise that the average American commits 3 felonies going about their daily business because there are too many laws in the country that criminalize conduct no one would even know was criminal. And I wrote License to Lie, Exposing Corruption in the Department of Justice, and self-published it at about the same time. We didn't know each other at all, but we both found ourselves being asked, as we talked about those books, well, what can we do to change this? How do we fix it? So Harvey started writing Conviction Machine and had the thought to call me and ask me if I would help. I was, of course, honored and delighted that he would do that. He's an outstanding lawyer with just a stellar career. And so we put our heads together and drafted Conviction Machine to try to give anecdotal examples of things that have gone so wrong in our criminal justice system in real cases affecting real people and destroying lives unnecessarily, and then propose some solutions for the problems.
And that we'll get to, too, is the solutions, because I always appreciate when you identify a crisis situation or a problem, something that needs to be remedied, and actually propose alternatives for how to go about it. But in terms of this Conviction Machine, you chose that title. Why that title, and what is the nature of the problem when you look at underneath the hood and see how it's come about and what it means today for Americans?
Well, it's multifaceted, of course, like most big problems are. First, there are too many criminal laws. We need a Walmart-sized rollback of our criminal laws, and it should be such that only Congress can make something a crime. Right now, agencies have made things criminal, which shouldn't be allowed at all, and Congress can fix that easily by simply taking the power back to itself where it should only be in the first place. Then we have overzealous criminal prosecutors. Some are absolutely malevolent and seek to use the law as a weapon to achieve social and political objectives. Others are simply naively or honestly overzealous in their desire to do their jobs. They need supervision, and they need to be removed from the protection of absolute immunity. As it is now, prosecutors cannot be sued for anything. They could deliberately make up a case against you, send you to prison, absolutely ruin your life, and do it knowingly and intentionally, and nothing can be done to them. Nothing is done to them. It happens all the time. Just ask Michael Morton in Texas, who spent 25 years in state prison while the district attorney who hid the bloody bandana that had someone else's blood on it and evidence of from his son that exonerated him, and that guy became a state court judge. Then when it was all uncovered 25 years later through DNA testing, the judge got 5 days in the county jail for Michael Morton's 25 years in state prison.
That's stunning. Sidney Powell, our guest, co-author of Conviction Machine. One thing I know, I'm not an attorney myself, but I was a legal assistant for a couple of years for an attorney, did a lot of family law, but also some criminal law. And I understand the importance of discovery, which is when documents are made available to someone who's been accused of a crime so that you can access and see what the evidence is. But you and your co-author identify in Conviction Machine one of the problems as being a hide-and-seek problem when it comes to discovery. Tell us more about that.
Well, a criminal defendant is entitled to have the government provide to him any evidence they have that shows he might be innocent or that contradicts their witnesses or their theory of the case, and anything that might mitigate the punishment against him. Prosecutors often don't do that at all, and they hide the evidence that shows people are innocent. That happened, and I talk about it at length in License to Lie, when 4 Merrill Lynch executives went to prison for a year on an indictment that criminalized innocent conduct, made a regular business transaction sound like a horrific crime when there was nothing wrong with it, and hid the evidence that showed the defendants were innocent. It took 6 years to find it. Meanwhile, they lost a year of their lives in prison when they never should have been there at all. The case should have been thrown out. Well, it never should have been brought, but it certainly should have been thrown out by the district judge on a motion to dismiss the indictment. So you have prosecutorial misconduct there. You have judges turning a blind eye to these things. They always want to believe the prosecutor. Nobody wants to reverse a criminal conviction. We've lost the presumption of innocence. The government convicts 98% of the cases it brings. As soon as jurors walk in a courtroom, their first thought is usually, well, I wonder what that guy sitting at that table did, instead of that man is presumed innocent and the government has to prove his guilt beyond a reasonable doubt. The whole deck is stacked against a criminal defendant, and when the might and weight of the United States government is focused on crushing an individual, that's what usually happens. The prosecutors also have the ability to stack charges, so they can, multiple statutes cover essentially the same conduct, but as long as there's one different element in each offense, and there usually is, they can add multiple charges for what amounts to the same conduct. For example, in the Enron litigation, the defendants had a 110-count indictment against them. Nobody can defend something like that. So one of the things we recommend is that there be some kind of limit on the number of charges in an indictment, unless there are individual specific victims that whose rights need to be protected by each count of an indictment.
You were a federal prosecutor for a while. Is this a new phenomenon or something that has been developing since even before you became a prosecutor?
It was not the way it was when I was a prosecutor. I worked for 9 different U.S. attorneys in 3 districts across the country under both political parties, and no U.S. attorney I worked for would have tolerated any of this for 2 seconds. And we were told to do it right, and not to stretch the law, and to look out for judges who might be overzealous in terms of sending a defendant to prison or not following his rights. I mean, I've been known to stand in the courtroom and tell a judge they couldn't do something that was favorable to the government, but it was wrong for the defendant. And I don't see people doing that anymore.
What changed? How did this come about?
In the last 20 years in particular, crossing both Democratic and Republican administrations, prosecutors have increasingly weaponized the law and sought to punch their own tickets to high-dollar salaries in international law firms and higher positions in the Department of Justice by getting their names in the paper every day. And even, I think it was President Bush, set up a white-collar crime task force on top of the Enron task force, essentially untethered them from the Department of Justice. And Michael Chertoff and Bob Mueller and Comey and people handpicked these prosecutors because they were terrorists of prosecutors. Well, a prosecutor's not supposed to be a terrorist. The job of a prosecutor is to seek justice, not convictions. These people have completely skewed the system and abused the dickens out of it.
One of the cases that always comes to my mind when we're talking about federal prosecutorial abuse, Sidney Powell, again, co-author of the new book, Conviction Machine, is about one of your clients, Michael Flynn. I mean, this is a guy who entered into a plea bargain, guilty plea, and then rescinded that plea. But the circumstances that led him to actually plead guilty and then later to rescind are very interesting. And I'd love for you to tell us what happened.
That is the greatest atrocity and blight on the face of the Department of Justice I've ever seen, and it's still ongoing. We have moved to withdraw his guilty plea on multiple grounds, not the least of which is the government's breach of the plea agreement, their bad faith and retaliatory conduct against him for the last year because he refused to lie at their demand in the Eastern District of Virginia in a case against his former business partner, and the judge in that case wound up throwing the case out. And also, his lawyers, they represented him before I came in the picture after his guilty plea, had an egregious conflict of interest. They had done the Foreign Agent Registration Act filing that the Department of Justice Mueller squad put in their sights very early on, and wound up essentially serving him up to the government. The whole thing is atrocious. The government made up the case from the beginning. We only learned this December, in what evidence it should have been produced to us long ago, that the FBI agents sent an agent in to what was supposed to have been a presidential daily briefing on August 17th, 2016, before the election, to collect information on Flynn, to assess Flynn in case they needed to interview him later, i.e., if Donald Trump was elected president. The timeline is this: Strzok and Page text about the insurance policy on August 15. On August 16, they open the case against Flynn, and on August 17, they send this agent into the presidential daily briefing to spy on him and Trump and collect information. And then that same agent wound up interviewing him in the ambush interview at the White House on the 24th of January. On top of that, their notes don't match the 302 that they generated, their FBI report. The government says they don't have or can't find the original FBI interview report. They produced multiple drafts that show significant changes. Things were added into the report that they then alleged were false statements made by Flynn that aren't in their notes at all. General Flynn distinctly remembers telling them several things that do not wind up in the notes, and the whole case is made up. It exemplifies every single thing wrong with our judicial system, including the fact that Judge Sullivan, who is the hero of my book, License to Lie, because he ordered Brady material produced in the Ted Stevens case, just denied us every shred of Brady material, including the actual documents that even the government acknowledged contained exculpatory evidence.
How does one get ensnared in a plea bargain feeling like they have no way out, even if later on they might conclude, shoot, I shouldn't have done that, and I was sort of doing, as you say in the book, a dance with the devil?
Well, it happens any number of ways. First, they crush you with threats of imprisonment for the rest of your life. They bleed you dry of legal fees to the point you have to sell your house and empty all your savings and start a public legal defense fund to try to defend yourself. Your lawyers don't tell you even all the evidence that the government has given them, the few meager disclosures that were made literally at the 11th hour after you'd already been coerced into pleading guilty. And they add on the threat of indicting your son, who just had a 4-month-old baby, the very next day if you don't take the guilty plea right then. All the while, they're hiding all the evidence that they have, that they know the charges were made up. They know the FARA statements weren't false. In fact, their own allegations of the FARA charges are what are the false statements. And it just rolls over you. It crushes you.
Sidney Powell, our guest, author of the new book, co-author of the new book, Conviction Machine, Standing Up to Federal Prosecutorial Abuse. Just a couple minutes left with you, and I'm curious, you mentioned one or two solutions before of what to do here. One of the items that you identify in Chapter 6 is an alternative to backroom deals that we see so often when these legal proceedings happen, particularly looking at immunity statutes. What do you mean by that, and are there other pertinent solutions that the Congress should be looking at, or at least the Justice Department, as far as improving upon the many fallacies we see right now in the system?
Yes, the government has the ability to give people immunity to compel their testimony, and that would be a far better use of power than compelling somebody to plead guilty to something they didn't do to save their lives. And distort the whole system. And yes, Congress can do a lot. One of the things Congress needs to do right now is amend 18 United States Code Section 1001 to include a provision in the false statement provision that no false statement prosecution can be brought without a warned and fully recorded oral statement for it to be based on. This business of allowing FBI agents to take notes and write up a 302 and the defendant not even knowing he's the subject of the interview. In fact, they schemed and planned. A large group of FBI agents got together, including McCabe and the general counsel for the FBI, to plan how to interview Mike Flynn, keeping him off guard and without even knowing he was the subject of the interview, not to mention not warning him of any rights or that they were investigating him at all.
Sidney Powell, you got to check out the book. Very interesting. Got it right here. Conviction Machine, Standing Up to Federal Prosecutorial Abuse. I really appreciate you taking the time. It is so many ways distressing, and hopefully members of Congress and also the Department of Justice will heed many of the warnings and solution ideas that you and your co-author, Harvey Silverglate, have in the book. So I appreciate you taking the time, and best of luck with Conviction Machine.
Oh, thank you so much. And my website is sydneypowell.com, so people can sign up for updates on the Flynn case and get more information about all of it and contribute to his defense fund.
Excellent. Well, thank you very much. Really appreciate your time and your dedication to this issue, Sidney Powell. Best of luck to you.
Thank you.
Once again, the book is Conviction Machine, Standing Up to Federal Prosecutorial Abuse. A very fascinating read, and not too long of a read either. A lot of times you look at a book and you think, oh my goodness, this could be an exceptionally long read and I just don't have the time. Well, first of all, you probably have the time because a lot of us are spending a lot more time at home right now. But also, it's not much more than 100 pages. Very interesting insights and observations to check out as well. Once again, Conviction Machine. Really, what has happened with Michael Flynn, the more I hear about it, the more stunned I am about how this whole process unfolded and everything related to Russiagate and so forth. It really is stunning. So here on Jimmy...